Hello world, microphone check, 1 2 1 2. Wow, Wayne, it's your cue. Let me know if you can hear me in the chat. Give me a 1, and we will get this party started. It's a paperwork party today. If you're in the replay, you can just skip ahead. Okay, wow, Wayne, waiting on that 1. Let me know if you can hear me. Or somebody. Let me know if you can hear me. Microphone check, 1 2 1 and a 2. All right. Hey, Faye. Yes. Thank you so much. Happy Saturday. So I'm here. Fantastic. All right. So I'm here to break down some paperwork. Last Saturday, I was here reading the government's response to Judge Subramanian's request for further information about their knowledge of the interagency MDC sweep, as well as Investigator 1 and their involvement. The government responded with signed affidavits, as well as a full breakdown of their knowledge of that sweep, as well as Investigator 1's involvement. Well, Diddy and his lawyer, Mike Agnifilio, has responded asking the judge first if they could respond to these affidavits. The judge granted their request, and now we are, I think yesterday they filed their 7-page response to the government's information. And if you see this on the thumbnail on the screen, we want to put the government on trial. They are still wanting, I guess you could call it a hearing around this whole situation. They want to put the government on the stand. They want to put them on trial, the investigator, as well as the prosecutors around the sweep. So let's get into the paperwork. I'm doing really well. Thank you, Faye. How about you? I hope everybody's doing well on this magnificent Saturday. Love me a Saturday. All right. So, all right, we're going to get right into it. Dear Judge Subramanian, we write on behalf of Sean Combs to respond to the declaration submitted by the government on January 17, 2025, and in further support of Mr. Combs' motion for a hearing, suppression, and other relief. Now, and like I said, I believe they're trying to either have a mistrial or have him get out, period. They want these charges dropped, and they're doing any and everything they can to make that happen. So the letter goes on. The declarations show that ever since the government first tried to sue Mr. Combs' privileged notes, I'm sorry, did I say sue? Let me start over. The declarations show that ever since the government first tried to use Mr. Combs' privileged notes to continue his detention, it has presented a materially false narrative about how it got access to these sensitive privileged materials containing his defense strategy and communication with his attorneys. Most significantly, the declarations reveal SDNY, or Southern District of New York, supervisors directed the BOP, or Bureau of Prisons, to search Mr. Combs' unit because of its investigation and prosecution of Mr. Combs. And they demonstrate the government has consistently monitored Mr. Combs' legal calls. In other words, they confirm what Mr. Combs has been arguing all along, that the search was conducted based upon a pretext not for any legitimate penological reason, and that Investigator One's surveillance before and during the search violated Mr. Combs's constitutional rights and invaded the attorney-client privilege. I'm going to interject before I continue this, because this is already pissing me off. I saw some other people covering this with headlines like, is Diddy getting out? And basically putting a lot of weight on this letter. I'm already reading this. This is my first time reading this with you guys. This is the same complaints they've already lodged. Now, it is my understanding that Mr. Combs is in jail. And it is my understanding that all the inmates are monitored and warned of such monitoring, even on recordings before they make their phone calls or during the phone calls. So I don't understand why they feel that he's being targeted and he's the only one being monitored in jail. So I'm going to go on. First, the declarations refute the government's repeated claims that the BOP sweep was carried out solely to further legitimate penological interests and did not target Mr. Combs. The declarations expose that after the sweep began, it was unclear whether Mr. Combs' unit would be searched at all. Okay, I'm going to stop again. What happened was they claimed they were spending a lot of time, more time than they expected. And because of that, they were questioning whether or not to search that particular unit because of time constraints. Now, I had questioned when reading that information, who was questioning whether or not they should search that particular unit. It was established in response to that it was already planned to search every unit. So why are we saying, well, we're spending so much time, how about we not search this unit? I was questioning who proposed to not search that unit, because it seemed to me this person is the person they should be questioning. The unit was already a part of the plan. It was only being questioned because of supposed time constraints. So what they're putting here in this letter is misleading, but I'm pretty sure the judge will see through this. I'm going to continue. Moreover, the search of that unit was carried out specifically at the direction of Southern District of New York supervisors, including the supervisor for this case, because of their interest in obtaining evidence against Mr. Combs. Second, the declarations show that Investigator One became an agent of the prosecution team and worked to advance its case. He searched Mr. Combs' bunk for evidence, not contraband, and it is clear his purpose was to gather evidence for the prosecution, not police any potential threats to MDC security. Indeed, it is notable that even though he has been surveilling Mr. Combs' communications for months, to this day, the BOP has not taken any actions to discipline Mr. Combs for any purported violations of MDC policies. Mr. Combs has never received so much as a write-up in his 4 months in BOP custody, despite the government's repeated complaints about his alleged obstruction from the MDC and supposed violation of policy. Okay, I'm going to interject again. So they're basically saying, they are telling you, the judge, that Mr. Combs has been breaking these jail rules and doing all these things that he wasn't supposed to be doing with these phone calls and text messages and emails. However, Mr. Combs himself had never received any write-ups. Well, Mr. Combs was told in court, just the same way you and the judge found out, and us, the public, when in court, the government let the judge know, as well as through court documents, that they have observed him breaking these rules. So regardless of getting a personal write-up or not, he was informed. He had been informed of the fact that the government had been aware of him breaking these rules. And what did he do after the emergency hearing when the government laid out all of the details about him breaking these rules? He turned around that very weekend and did it again. So to say that he wasn't warned and there were no write-ups, and the government also let everybody know that they are running a covert, ongoing investigation. Okay? And if he is smart, he wouldn't be doing these things because he would know, like every other inmate, that you don't say certain things on the phones. You don't use other people's IDs to use their phone time. You don't use other people's IDs to use their text messaging and email services. All right. And with regard to those notes, I'm just going to say this too. Since they want to say, oh, they were spying on his legal notes. Legal was not on the notepad. The judge already admonished them for lying about that. The pictures determined that those notes said things to do. That's it. They didn't even need to use those notes at all. So to say that this is a reason for him to get out or for him to have his charges dropped because his rights were violated is complete BS. All right, I'm going to go on here. Third, the declarations confirm that the government was complicit in Investigator 1's continuous monitoring of Mr. Combs' privileged communications. Investigator 1 admits he listened to Mr. Combs' calls, including with his counsel, and that all those recordings, including the ones with attorneys, are being furnished to the U.S. Attorney's Office. Isn't that his job, to monitor and provide the information that the rules are being broken? Now they're saying that they provided information saying that he was monitoring the calls, including with his counsel. I don't know. I don't know where they're getting that from. The affidavit, one of them was sealed because it had information about the investigator. So I don't know if they're getting that from that sealed affidavit, but okay, I'm going to go on. Finally, the declarations raise additional questions that cannot fully and accurately be answered except through discovery and an evidentiary hearing. So they want an evidentiary hearing and they want discovery with regard to this MDC sweep and this Investigator 1. As just one example, despite reporting to prosecutors that he personally took photographs of Mr. Combs' notes, then we have a whole line redacted there. Whatever this example is. It says the declarations are inconsistent with each other. They omit key details and rely extensively on hearsay and are remarkably vague as to key points. The truth will only be fully revealed if the government's claims can be tested through cross-examination of witnesses who have actual knowledge of the material facts. Likewise, the court cannot fashion appropriate remedies without the complete information that can only be discovered through such a hearing. Now, I'm questioning whether or not they have a mole in the MDC. And I'm saying that because Agnifilio's wife had a long time high-ranking position as a prosecutor for the MDC, for the Southern District of New York. And as well, somebody was trying to get them not to search that unit during that sweep. It just doesn't make sense. Something is off. But I'm going to continue. Number one, the government misrepresented the facts and tried to conceal the constitutional violations. A, SDNY prosecutors, not the BOP, directed the search. So they're now saying the prosecutors directed the search. Now, the government already let them know that this search was being planned back in last summer and that the prosecutor's team handling this case was not involved. So I don't understand why they're saying this, but let's see why here. The declarations contradict the government's prior representations concerning the reasons for the search and who directed it. The government previously claimed that the MDC sweep was planned by prison officials well in advance of Mr. Combs' arrest, was motivated solely by legitimate penological interests, and did not target Mr. Combs. It further claimed no one on the case team supervised, conducted, or participated in the search, and that the search was organized and executed primarily by BOP staff. These claims are essential to the government's opposition, which rested on the notion that prison officials are presumed to do their best to evaluate and monitor objectively the security needs of the institution, including in deciding whether a search is necessary. But these claims were false. The truth is that the search of Mr. Combs' unit apparently was not even a part of the BOP's original plan for the sweep, but it was SDNY supervisors, including the trial team's own unit chief, Supervisor 1, who ultimately directed the search. And the search was conducted not for legitimate institutional security reasons, but because Supervisor 1 was interested in searching Mr. Combs. Specifically, on the morning of the second day of the sweep, representatives from the BOP and other federal agencies met to discuss a potential sweep search of Mr. Combs' unit. The agencies had not previously decided whether such a search was necessary and inquired into the position of the USAO and the SDNY regarding the potential search. That is just not true. They said in the beginning it was a plan to search all the units. It was the time constraint that had them questioning searching his unit. I don't understand why they keep saying this. Okay. And also, it was between the Southern District and the Eastern District, whether or not they had conversations with both of those districts' supervisors. All right. Supervisor 2 and SDNY unit chief who helped plan the MDC sweep. And, position of the USAO, SDNY regarding the potential search. Okay. Supervisor 2 and SDNY unit chief who helped plan the MDC sweep and was present during the sweep, then discussed with Supervisor 1 whether Mr. Combs' unit should be searched. Supervisor 1 stated it should be searched in part because of what the prosecution team had learned regarding Mr. Combs' conduct at the MDC. Supervisor 1 conferred with SDNY senior leadership and relayed to Supervisor 2 that Mr. Combs' unit should indeed be searched, which Supervisor 2 further relayed to the BOP, leading to the search. Thus, while AUSA Slavic claims no SDNY personnel directed how the search of Mr. Combs' unit would be conducted, she can't deny that SDNY supervisors directed the search itself. That flatly contradicts the government's prior representations. B, Investigator 1 was searching for evidence and not contraband. The declarations also contradict the government's prior narrative concerning its relationship with Investigator 1 and his motivations. The government previously claimed the case team's investigation and the BOP investigation have operated independently at 16, and that Investigator 1 was merely searching for contraband, not evidence, during the sweep. The declarations show that both of these claims were false. In fact, the government and Investigator 1 worked in a coordinated fashion for at least 2 weeks leading up to the MDC search, and the trial team encouraged Investigator 1 to monitor Mr. Combs' communications. BOP personnel contacted Supervisor 1 on October 10, 2024, to inform her that Investigator 1 was monitoring Mr. Combs' communications and found relevant evidence. That date is significant because it was 10 days after Mr. Combs filed his widely publicized notice of appeal concerning the detention order, and the same day the court invited the defense to make a renewed bail application. Notably, the SDNY supervisors on this case have been present for all court appearances in this matter, including that October 10th conference. And they've redacted out something here. He spoke with AUSA Slavic on several other occasions in October and November of 2024. Slavic declared, although AUSA Slavic never specifies when or in what capacity these conversations took place or what was discussed. Investigator 1 clearly became an agent of the prosecution team. He collected, screened, and shared evidence while collaborating with a trial team prosecutor, and the fruits of his investigation were ultimately used by the government to try to detain Mr. Combs. He made a point of alerting them to Mr. Combs' plans to discredit possible witnesses and find dirt on people. In other words, core defense strategy protected by the Sixth Amendment, unrelated to any legitimate penological concerns. And the prosecutors have used the information Investigator 1 illegally obtained in various ways. We cannot know the full extent of the improper uses of the fruits of the search without a Castigar hearing. But, for example, and this is redacted out, and the footnote is also partially redacted. All right. The second footnote, well, let me see. I lost my place. Pressing the wrong buttons. I didn't bring my mouse with me. Okay. Let me find my place. All right. Let's see. Page 4. And despite the government's claims that Investigator 1 was monitoring Mr. Combs because of purported violations of VOP policy, Mr. Combs has not once been disciplined or even asked by the MDC to stop engaging in the cited conduct. Because they're investigating him, of course they're not going to tell him to stop. If the Investigator 1 surveillance was genuinely undertaken solely for penological purposes, why does it seem that the fruits of his work have only been used by the prosecutors and not the BOP itself? Clearly, Investigator 1 searched Mr. Combs' notes during the sweep to find evidence for the prosecutors. He was not searching for purported contraband as the government previously represented in court, to the court. There's a whole almost paragraph here. It's redacted. Oh my gosh. Hold on. Okay. Clearly, Investigator 1 searched Mr. Combs' notes during the sweep to find evidence for the prosecutors. He was not searching for purported contraband as the government previously represented to the court. Moreover, AUSA Slavic states that the BOP was looking for narcotics, weapons, and electronic devices, none of which could possibly be found in the pages of Mr. Combs' notes. The contraband excuse was thus clearly a pretext for the unlawful search. C. The government did not proceed in good faith and took no steps to avoid violating Mr. Combs' rights. The declarations confirm that the government has, via Investigator 1, consistently monitored Mr. Combs' privileged communications with his attorneys. In its opposition to the defense motion, the government claimed it made good faith efforts to avoid coming into contact with privileged material, and that it is contrary to facts and logic to suggest Investigator 1 was its informant in the defense camp. But it turns out Investigator 1 has been spying on the defense team all along. Investigator 1 thus repeatedly informed the trial team he was eavesdropping on privileged communications, but the trial team never instructed him to stop. And there's a footnote. Okay. That is outrageous. Worse, the trial team endorsed his conduct by requesting the communications at issue. Accordingly, the government has obtained and produced the defense over 30 of the defense's own calls with Mr. Combs. The footnote 2 says Mr. Combs already described other ways in which the government may have already made use of the notes apart from its bail arguments. And it is possible the government shared contents of the notes with additional parties such as witnesses or alleged victims whose counsels are often in court, further prejudicing the defense. 3. Mr. Combs' bunk was searched yet again and his items rifled through on December 24th, 2024. So they're saying there was another search on Christmas Eve. That is an egregious breach of Mr. Combs' rights, and the court should immediately order the government and the BOP to cease any such spying on the defense camp. And there's a footnote. Footnote 4, the government claims it directed Investigator 1 to produce the recordings to the filter team, but that is cold comfort for this egregious breach of Mr. Combs' Sixth Amendment rights. As we explained in prior submissions, the filter team process has failed, as the production of multiple privilege notes to the case team, which the court had to order clawed back, amply demonstrates. In addition, since the filing of this motion, we have discovered multiple additional instances of privileged material being produced by the filter team to the case team. For example, after the defense counsel alerted the case team to the existence of a potentially privileged notebook for Mr. Combs' Miami residence that was searched in March 2024, the notebook was produced from the filter team to the case team without any input from counsel. It was not until his instant motion that the defense was given the opportunity to make privilege determinations regarding the notebook. Additionally, multiple communications from an attorney at a law firm that has been on counsel's privilege list since April had been in the case team's possession until the defense asked for them to be clawed back. The defense has initiated other clawback requests in connection with additional privileged materials the filter team passed to the case team. Number 2, the declarations show that further discovery and a hearing are required. A, the Slavic Declaration is permeated with unverified hearsay and lacks crucial details. The Slavic Declaration is largely based on unsworn hearsay, much of which is vague and raises more questions than it answers. For example, the discussion between unidentified BOP personnel and Supervisor 1 on October 10, 2024 lacks any detail. Important questions remain. Who are the BOP personnel? What was said? Why was Supervisor 1 contacted seemingly out of the blue by BOP? And how did the BOP know who to contact? Based on the chain of events, it is likely the BOP had standing orders from Supervisor 1 or other Southern District personnel to monitor Mr. Combs and report on his conduct. When were such orders given and why? Were there other communications leading up to this call? AUSA Slavic also fails to share what she potentially discussed and when with Investigator 1. She merely states, I spoke with Investigator 1 on several other occasions in October and November 2024. But again, glaring questions remain as to what was said and what expectations arose from these communications. There's something redacted. The declaration further references, without describing, multiple conversations and meetings involving BOP personnel, certain SDNY personnel, and other government officials. It references multiple other conversations and meetings between Supervisor 2 and Supervisor 1, during which the supervisors specifically discussed Mr. Combs. There are other references to conversations between Supervisor 1 and Southern District senior leadership. The court's consideration of Mr. Combs' motion should not be based on such rank, nondescript hearsay. Further discovery and testimony from these individuals is required. As just one more example, the Slavic Declaration states Investigator 1 provided a high-level overview of the contents of the BOP notes, including the defendant's plans to discredit possible witnesses and find dirt on people. What specifically did Investigator 1 say? What witnesses were identified? And what else was communicated regarding the notes? Perhaps directing Investigator 1 to provide the photographs to the filter team in the first instance provided some cover for the case team, but if the high-level overview revealed the substance of the notes, it was not a legitimate way to ensure that the case team was not tainted by access to privileged information about Mr. Combs' defense. B. Investigator 1's declaration lacks important details. Curiously, in contrast to the Slavic declaration, Investigator 1's declaration nowhere states that he described the contents of Mr. Combs' notes to AUSA Slavic. Compare blank with Slavic Declaration 16. Why the inconsistency, and what is he hiding? Inconsistencies like this undermine the credibility of the declaration and further underscore the need for a hearing. Indeed, it is clear Investigator 1 previously misled prosecutors by telling them he took photographs of Mr. Combs' notes. That is apparently not true, yet Investigator 1's declaration still fails to identify the individual who actually took the photographs. Who is this person? What did he do with the photographs? Who else saw them? And did the government have any communications with this individual? Did the government ever interview that individual before filing its response to Mr. Combs' motion or to comply with the court's order to file the declarations? C. The prosecution team also includes Supervisor 1, Supervisor 2, and Southern District Senior Leadership. The government uses a severely limited definition of prosecution team in an attempt to withhold critical information and dodge accountability. But as explained in Mr. Combs' motion, the rights at issue proscribe unlawful searches by government actors, generally including any BOP and USAO employees, not just searches carried out by the case team. In any case, the prosecution team, as defined by the Second Circuit, plainly include the SDNY supervisors and senior leadership. It includes, for example, the prosecutor's office. Generally, they use case law here for that to describe how an individual prosecutor is presumed to have knowledge of all information gathered in connection with his office's investigation of the case. Supervisor 1 and Supervisor 2, as well as Southern District's senior leadership, are not far-flung members of the executive branch. They're using more case law. These individuals regularly observe the proceedings in this case and supervise and sign off on trial teams, investigative activities, and trial strategy. The court should order discovery and declarations from these individuals and eventually take their testimony at a hearing. D. The government should produce the emails and other evidence. The government mentions email communications, and the MDC is wired with surveillance cameras that recorded the relevant search. The court should order the production of this evidence and any other evidence in the government's possession relevant to the motion. It is the most reliable means of testing the government's dubious claims. Instead of sharing the full story, the government has cherry-picked a few facts and submitted declarations that undermine the credibility of its previous submissions, omit key facts, and raise numerous important questions about what really happened. A full hearing in which Mr. Combs' counsel are afforded the opportunity to cross-examine the government actors with knowledge of the facts relevant to the search is the only way to find true facts and understand the full picture so the court can assess how best to remedy the grave violation of Mr. Combs' constitutional rights. Mr. Combs therefore respectfully requests that the court order the government to produce the additional discovery described in this letter, as well as whatever communications it has already shared with the court in camera, and hold a hearing. Respectfully submitted, Alexandra A.E. Shapiro. Jason A. Driscoll, who is a brand new attorney that Diddy has retained, and Mark Agnifilo, Tinny Garagos, and Anna Estevio. Oh wait, Estavio. I can't pronounce that. Esteveo. There we go. Anna Esteveo. So she's another. She might be another new attorney. So he's bringing on new counsel. Probably one's better equipped to handle this disagreement they're having with the government and wanting to get this trial done prior to Diddy's trial. They want to put the government on trial, and they want to establish the fact that Diddy rights have been violated so they can get him out. Let me come over to the chat. Let's see. Hey, Queen. Let's see. Faye said, if he gets out, I will faint or something. What on earth are the feds playing at? It's almost like they low-key don't want him in jail. I wouldn't necessarily say that. Let's see. Queen said he's still going over the MDC searches. Exactly. Yeah, he's still bitching about the search. Diddy's team doesn't want to get to discovery. Queen said looking for any technicality. Yep. This won't drop charges. Other blogs is starting to be clickbait. Exactly. That's exactly what my point was earlier. A lot of that stuff is clickbait. And I'm surprised by a couple of them because they don't usually do stuff like that. So I guess people are getting desperate for views. I mean, who cares? I don't know. I just don't get it. Thank you for the bells, Wow Wayne. Queen says, so why wouldn't more inmates get out if this is called jail? Exactly. Other inmates are going to follow suit, complaining about the fact that they were monitored and caught doing things and weren't able to get bombed because they were caught doing things that were breaking rules. Like, what? Faye said, it's prison, not a holiday. Hey, beautiful spirit. Happy Saturday to you. Faye said, okay, Faye, something's definitely off. Yep. I thought searches were standard practice in prison. Beautiful Spirit said Diddy and his attorneys are crooked as two left shoes. Leave it to Beautiful Spirit to make me laugh. Diddy's team are really starting to annoy me. They keep bringing up the same things. It's ridiculous. Can they not come up with something new? It's like they're stuck on repeat or something. May you all have a wonderful and blessed day. Love you too. Faye said, I wonder who investigator one is. It's very strange. Well, they provided that information through a sealed affidavit because they don't want the public to, I guess, get a hold of this person's information. He probably needs a new counsel. This is one big mess. Yes, please hit the like button. And Wild Wayne said, guilty, guilty, guilty. So I don't know if you guys understand my frustration with this, but listen, I get it. This is what they're supposed to be doing, his lawyers, right? I'm pretty sure a lot of this is at Diddy's direction. He's making sure their lights are staying on, okay? So I'm not sure that the government, I guess at this point, the judge is going to make a decision or may come back with more questions or wanting more information. I'm not sure, but I will definitely be looking out for whatever comes next in this filing or these court dockets here. I appreciate y'all joining me on this Saturday. I don't know if you could hear it in my voice. I'm kind of fighting off something I was feeling this morning. I'm drinking some tea. I did that heavy gargling and I might have to take something. I don't usually like taking no medicine, but I'm trying not to get sick. I don't need no illnesses. Okay. So I appreciate y'all. I want you guys to have a wonderful Saturday. I might come back because Jay-Z, there's an update with the Jay-Z Busby thing as well. I wanted to do that separately. So make sure you're watching out for these notifications, and also going over to the Nosy Goddess, Nozey Goddess channel, and checking out my uploads over there. I'm working on something for that as well. All right, y'all. Love you much. Peace.